I will now call the second case on the morning docket, case number 119739, State of Kansas versus D'Angelo Martinez.
The first time I've done that. May it please the court, Kristen Patty appearing for the appellant, D'Angelo Martinez. Your Honor, I'd like to reserve 3 minutes for rebuttal.
3 minutes is reserved.
This is a companion case to the next case on the docket, Christopher Patillo. One April afternoon a few years ago, out in the mall here, two rival gang members had a little altercation. And then the next afternoon, one of those gang members, Mr. Patillo, drove a van by the other one's house. Shots were fired, and the other gang member's brother was killed in the front yard. Two people that were in the van say that the gunman was my client, Mr. Martinez. Mr. Martinez went to trial had a 5-day jury trial. The jury hung and was not able to reach a unanimous verdict. Several months later, there was another 5-day jury trial. This time the jury did reach a unanimous verdict, convicted Mr. Martinez of premeditated first-degree murder and felony murder, as well as some other charges. Mr. Martinez is currently serving a hard 50 life sentence, and on the remaining counts, he got something like 86 months. We're here because when the state gave its rebuttal closing, the prosecutor said, "Now, I want to close with talking about sort of an overview of what's happened here. This may seem senseless to you in the way that it makes no sense. Why on earth would someone just shoot at someone for no good reason? The state has presented evidence that explains that. The defense has speculated about other people's motives, but the state has actually presented evidence." At this point, defense counsel objected. He requested a sidebar. He told the district court judge that he believed that the prosecutor's statement not only impacted his client's decision not to testify, but the fact that they did not present really any sort of a case at all here. There had been no opening statement either at the beginning of jury trial or once the state rested. As I said, Mr. Martinez didn't testify. There were no witnesses presented. Defense counsel was not required to object. This is something that you could consider on appeal despite an objection. But it's important here because the fact that the district court judge not only overruled the objection, but also didn't give the jury any sort of a cautionary instruction affects your analysis of that. I've cited Pursley for the holding that improper remarks made by prosecutor in closing summation generally not basis for reversal, where jury was instructed to disregard the same. And that didn't happen here. So Mr. Martinez alleges on appeal that this violates his Fifth Amendment right against self-incrimination, but also his Sixth Amendment rights to a jury trial. And I apologize for any misconstruing of that one of my paragraphs in this regard. I cited chronic because I really like the phrase crucible of meaningful adversarial testing that we get from that. I wasn't trying to suggest at all that I didn't think defense counsel did his job. I think he did do his job. It's just that's what we've got at issue here. the Fifth Amendment right and the Sixth Amendment right to make the state prove its case. And that's what Mr. Martinez is alleging on appeal that the state violated with that statement.
You want us to take this statement that relates to motive and extend it to all aspects of the case? Is the way I understand your argument?
Well,
or do we just focus on the lack of proof of motive?
it's really on the fact that, the state is prohibited under Griffin from commenting on Mr. Martinez's failures to testify or to present any evidence in his defense.
And where is that statement found here? Because the statement is in the context of speculation about motive. There's no broad. That's the reason for my question, because I don't read it as a broader statement that the defense could have. It's not one of those just general out of context. The defense could have brought you evidence, but they didn't.
Right.
Kind of statements that we have found to be.
I guess probably of the cases that I cited in the brief where reversible error was found, the 1986 Court of Appeals case, Jagger, is probably the most similar. We had no direct testimony about Mr. Jagger's intention. Mr. Jagger is the only person who really knows of his own experience what his intention was. And then also, as there was a second statement in that closing argument, you have no direct testimony from the intender as to his intentions. And I would suggest to you, is that really any different?
Do you agree or disagree factually with the prosecutor's statement that the defense has speculated about other people's motives?
I guess I disagree. Certainly a defense counsel, even in a situation like this, has to do his job.
But isn't that what the defense counsel was doing? Was talking about other people's motives?
Well,
that's just in the record, isn't it?
It is.
And so, but if that's the case, what's error in the state pointing out that while the defense defense counsel has talked about motives, the state has produced evidence? Why is that error?
Because this is, first of all, the kind of things that, and I expected actually probably from you also a question about the harmless inquiry. This is one of the thing that you and the United States Supreme Court have told prosecutors that they absolutely, positively cannot do. If you think that that's what this statement was. Well,
we've told, I'm sorry to interrupt, but I think we've told prosecutors, as you've argued correctly, you can't comment on defendant's silence,
right,
or refusal to testify. You can't say the defendant could have produced evidence but didn't. But in our recent Haygood case, we did say that it is not error for a prosecutor to point out a lack of evidence to support a claim being made by the defense. And that seems to me to be close to what happened here. If, in fact, the defense attorney gave an alternative argument to the jury, isn't it fair game for the prosecutor to say, well, the defense attorney has given you this alternative argument, but we've actually produced evidence?
I guess the problem here is that Mr. Martinez was alleged to be the shooter. So then you've got the question, why on earth would someone just shoot at someone for no good reason? He's the only one who can explain that. The defense counsel has to try to do his job, even in a case like this. And I think it just...
Well, but to be consistent, I'm sorry to pick on this,
That's
but
right.
To be consistent with your sort of theory of how this case went down, it would seem to me that defense counsel could do his or her job by simply arguing that the state has failed to meet its burden, as opposed to proffering an alternative explanation.
Well, is there another way then that the prosecutor could have said this? That I wouldn't be talking about here, that wouldn't have gotten an objection from defense counsel. To me, this is another 5-day jury trial. It can really also be read, and we do consider what it might have sounded like in the minds of the jury. Boy, Mr. Martinez has really wasted your time this week because he didn't present any evidence. And of course, he's not required to. And like I said, that kind of goes to the harmless thing, part of the analysis. I think the fundamental question for you here is whether you consider that statement to be error. Because as I've said, the rights alleged that were to be violated here, this is really a bright line. You just can't do it.
So the state is stuck with an implication that they're hiding the ball from the jury?
I guess I'm not sure what you mean, Your Honor, by hiding the ball.
Well, the defense counsel stating, look, there are other things for you to consider that haven't been presented today. And your position is the state cannot point out if the defense thought it was relevant, they also could have subpoenaed witnesses or brought this evidence forward. They're simply stuck with saying nothing to the implication that there are other facts out there are other things for you to consider, but you don't have them to consider.
Well, a lot of other times in similar cases, some of the cases that the state cited in its brief, the defense maybe gave an opening statement about what they said they were going to prove. And that's what courts have sometimes relied on saying, remember back at opening, they told you they were going to prove this and then they didn't. And that's permissible. But here, of course, there wasn't an opening statement at either point. And therefore, there wasn't the promise by the defense or suggested promise by the defense that there was going to be any other sort of evidence presented. So I don't know if that answers your hiding the ball question or not.
Not really. I mean,
Okay.
This is closing.
Right.
And you're saying that the state cannot do anything other than say, well, we presented what we presented. You have the evidence to consider.
I think that this statement goes too far. Like I said, it's particularly looking at Jagger, it speaks to Mr. Martinez's intention. He was the person that they say fired the gun, that supposedly shot at somebody for no good reason. And that's why I believe that his Fifth and Sixth Amendment rights were violated here.
If the prosecutor's statement had been, the defense has speculated about other people's motives, but you have heard evidence about motive, would that have been error?
I don't think so.
And what's the difference if in the case the only evidence that was presented by the state?
Because particularly
that's the jury would know that. The jury would know that it was only the state that had presented the evidence.
Because the last statement of what I read, the defense has speculated, but the state has actually presented evidence. That seems to be shifting the burden to the defense in order to present evidence, which they're not required to. I know my time's up, but I'm not seeing any other questions.
Thank you, counsel.
Thank you.
May it please the court. My name is Curtis Wired and I represent the state of Kansas. Excuse me. Your Honors, the defense's theory of this case was that Christopher Patillo was the shooter, not his client. Now, because the state had presented direct evidence that Mr. Martinez was the one who in fact fired the gun, defense counsel had to argue in closing arguments that these witnesses, along with another individual, were simply lying under oath when they pinned the shooting on Mr. Martinez. In doing so, they relied on evidence in the record. Particularly in regards to Mr. Patillo, they argued that because he had testified that he had already been convicted of first-degree murder and he had been convicted, didn't mention anything about sentencing, but and that his case was pending on appeal, the defense counsel posited in closing arguments that he may work out some kind of deal with the state. Whatever that deal would have been isn't clear. Also argued that Mr. Munch had recently accepted a track scholarship and that any charges that would arise from this incident could jeopardize that scholarship, thereby giving him motive to lie. And then he also argued that Mr. Fulton lied because he was covering for Mr. Munch, who was his, as he said, full-blood brother, and whose van was used in the shooting. So the reason I say all this is because we see, when we fast forward to the statement that's at issue here, it says defense has speculated about people's motives. That speculation isn't about defendant's silence, it's about evidence in the record.
One of the things that's a little troubling about this is whether or not an attorney in closing argument can just characterize. Because I think what you've described is a reasonable defense strategy under the circumstances. You just attack the credibility of the witnesses who are testifying against your client, and then you talk about that in closing argument, ways in which that credibility might be suspect. But the state's attorney, the prosecutor, when that person got up in closing, then characterizes that as speculation rather than evidence, just like everything else that came in that the jury could observe and listen to. Does the use of that word necessarily imply that the defendant has not come forward with actual evidence? I mean, I think that's what we're struggling with here. You've got two problems. Potential comment on the defendant's silence and a potential shifting of the burden, right? And obviously the defendant doesn't have to come forward with any evidence, and it's perfectly acceptable for defense counsel to just challenge the credibility of the state's witnesses, right?
Correct.
So is speculation kind of an overstatement of what occurred here? Yeah.
Sorry. I don't believe so, Your Honor. I think I would direct this court's attention to Butler, where you recently stated that characterizing the defense's theory of the case as ridiculous is a perfectly acceptable way of commenting on the believability of the defense's theory of the case. I think that's what speculation here means. It's not that defendant didn't come forward and testify. It's that what the defense had just told you moments before, based on evidence in the record, just simply isn't believable. Just as saying defense counsel's theory of the case is ridiculous, i.e. it's not believable, speculation is doing the same work here. So once we look at the comment, or the structure of the comment, we see that what that the state has actually presented evidence is being contrasted with defense's speculation. So I think that the structure of the comment cuts in the state's favor. And then I believe also another reason we can tell that this was not a comment on defendant's silence or a shifting of the burden was that we had a timely and specific objection raised below by defense counsel where they argued, as they are arguing on appeal, that this was a comment on the defendant's silence. The prosecutor is arguing, as I am arguing here today, that no, it was a comment on defense counsel's theory of the case. So, and then the district court, which was in the best position to see this comment and see how the jury would naturally and necessarily receive this, ruled in the state's favor, finding that this was not a comment on the defendant's silence. So I think because we have an independent view of this down below, the presence of an objection in this prosecutorial error case cuts strongly in favor of the state. And if I can, I'll just jump back a little bit to the comment structure. I forgot to mention that perhaps in response to the earlier question, that the federal cases I cite, I believe, also make a good distinction between defense counsel's statements in closing arguments and a defendant's silence. So I think in this case, it's pretty clearly within the context of this comment going to defense counsel's comments, not to the defendant's silence. Now, if this court were to find that this statement was error, the state would ask that you find it harmless for 4 reasons. First, because this would be a minor aberration in a prolonged trial. This was a 5-day jury trial in which 23 witnesses testified and 119 exhibits were submitted to the jury, which suggests that the jury probably wouldn't be parsing this statement as we are here today at the tail end of this long trial. And if it had, my second point is that the jury was instructed in 2 different instructions that it could not consider defendant's silence in reaching its verdict, and that it could not infer any level of guilt because he did not testify. I also mentioned in my brief several instances in which the prosecutor used the word actually throughout, and in many times you read those statements and you're not entirely certain why the word actually is in there. I suggest the court could read that this may have been a verbal tick, and it perhaps was just coming to the prosecutor's mind, not knowing what he was saying. And then lastly, while it's a secondary consideration, the evidence in this case is strong that Mr. Martinez was in fact the shooter, and that would cut in favor of finding this harmless beyond a reasonable doubt. If there are no questions from the court, I'll yield the rest of my time, and I ask that this court affirm Mr. Martinez's conviction.
Questions? Okay. Thank you, Mr. Martin. You reserve 3 minutes.
I think the suggestion that the word speculation may be akin to the word ridiculous, which has been found to be acceptable, or at least under that circumstances, is not appropriate here. It might be different if there was something about, the defense has suggested to you that other people may have had motives to do this, but you're the ones who have to judge the credibility of all the witnesses, right? I mean, that would be permissible. It's in some ways it's the point that the state has actually presented evidence, the suggestion that the defense did not present any evidence that I believe that is problematic here. And I believe I already spoke to it, as Sherman, as regards the harmless inquiry, prejudice can be found even in a strong case. As I said before, this is one of those things that you've told prosecutors you just absolutely, positively cannot do. And for that reason, we would ask that Mr. Martinez's convictions be reversed and then he be provided with a new trial.
Other questions? Okay. Thank you, counsel.
Thank you.
Thank you to both counsel for your arguments today. We will now take this matter under advisement. And